We were in an association assembly. So the CPIO is and so all the associations that are under the umbrella for administrative providers for the National Center has had an association. Assembly association. Yeah. So it was a leadership and the leadership of all association. They don't support us. Yeah. It's at my fault for both days. So yeah. You might try to yeah, he is. Really. Yeah,
how does it not help? So it's yeah, anything second degree down.
I was thinking that made
And plus, I mean, I don't have it's crazy to why I'm not genuinely. I want it
my name is yeah, I know. So
All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. Welcome to the Kansas Supreme Court. I will draw attention to the fact that Justice Wilson is not sitting with the court for these cases. We'll ask Mr. Doug Shima to please call the 10:30 docket.
The first case on the 10:30 docket for Monday, March 31st, 2025 is appeal number 125851, State of Kansas versus James D. Boatwright. Shawnee County briefs both sides.
Kristen Patty appearing for the appellant, James Boatwright, present and ready for argument. And may I reserve 3 minutes for rebuttal?
3 minutes is granted. Thank you.
May it please the court, good morning. The state appears by Deputy District Attorney Jody Litvin, present, ready for argument.
Second case is appeal number 125754, State of Kansas versus Tashara D. Yeargin-Charles, Jackson County briefs both sides.
May it please the court, Ryan Eniger, Assistant Appellate Defender, appearing on behalf of the appellant in this case, Mrs. Yeargin-Charles, present and ready for argument.
May it please the court, Chris Elsleger, Deputy Solicitor General, appears for the state, present and ready for argument.
Your Honor, that concludes the 10:30 docket.
Thank you, Mr. Shima. We'll call 125-851, State of Kansas versus Boatwright.
Again, may it please the court, Kristen Patty appearing for the appellant, James Boatwright. I've raised 2 issues in the brief and I've done it a little bit, I suppose, differently. It just made more sense, the facts, to put the prosecutorial error and closing argument, make that the second issue, because the first issue involves the testimony of a cooperating witness who we disagree whether or not he's an accomplice. So I'm going to start out with actually the second issue. This court in various decisions have said that a prosecutor in closing argument cannot do certain things. The prosecutor cannot comment on the fact that the defendant, when he's questioned by the police, invokes his Fifth Amendment right to remain silent. The prosecutor can't comment and call the defendant a liar or use any euphemisms, other terms that may impact the credibility of the defendant. The prosecutor cannot vouch for the credibility of any prosecution witness. The prosecutor cannot misstate the burden of proof and switch it to the defendant. And the prosecutor cannot appeal to community interests. Mr. Boatwright argues in this appeal that the prosecutor in his closing argument in this case not only committed one of those errors, two of those errors, but all five. Obviously, a lot of it comes down to how you read the words and in context. I know my colleague has accused me of cherry picking, and she reproduced, I think, at least the entire rebuttal argument in her brief for you. However, also I need to make sure that I highlight specific things that this prosecutor said. Mr. Boatwright, when he was questioned by the cops in the police station, and when he was advised that he was going to be charged with first-degree murder, he invoked his right to remain silent. And the United States Supreme Court, in an opinion called Doyle v. Ohio, and I'm saying mostly that for anybody is watching, has said that after that, you can't comment on the fact that a defendant has exercised their right to remain silent. Otherwise, that the effect on that right is going to be chilling. And so that's what, when we talk about Doyle rights, that's what we're talking about. This prosecutor said in closing argument, he contrasted it to that one witness, Keyshawn Ivory, who did talk to the police. And he said, unlike Keyshawn Ivy, who was brought down to the police station and then interviewed for several hours, the defendant has had the opportunity for months to prepare his testimony. It's making a comment on the fact that Mr. Boatwright did not avail himself at the first opportunity to try to clear his name of any culpability in this case. That kind of variation on that same statement also goes into the next thing. He called in several places. He called Mr. Boatwright a liar. It's something that not only has this court said that a prosecutor cannot do, it is also in our ethics rules, 3.4E, that it is prohibited. And so that's why it's not only prosecutorial error, which we've gotten away from calling it prosecutorial misconduct, but it is also misconduct in this case. He insinuated that Boatwright was a liar when he stated, "You have reason to believe that a person who gives you a story that they want you to believe or that they want you to hear that gets them out of trouble is more likely to not be telling you the truth."
And haven't we said in the past that prosecutors are permitted to ask jurors and to argue to jurors that they ought to weigh the credibility of the defendant's testimony? And whenever a prosecutor does that, aren't they effectively, in your words, insinuating that the defendant's story is not credible, i.e. untrue?
Well, right. And
so how do we split those hairs?
Well, and certainly, a prosecutor is within bounds, so long as they're telling the jury to use the same caution as any other witness in considering the defendant's testimony, pointing out any bias affecting his testimony, and making an evidence-based argument as to why other testimony were perfected poorly.
And isn't that what this prosecutor was doing?
Well, I don't want to concede that with this one statement that I just read, but that's not the only statement that this prosecutor made. He said, for example, the defendant has had the opportunity for months to prepare his testimony, to look at all of the state's evidence, the videos, the police reports, and the records. And if it were his desire, he could craft or come up with testimony. And it appears that he has testimony that sort of bobs and weaves around all the various pieces of evidence that the state has. He uses the word weave again in another place in the rebuttal argument. And you've said in other cases that you cannot use other words, caught in the web, snowing, yarn, fairy tale, fabrication, tall tale, spin. How is bob and weave any different from those other things that you've said in different cases constitute prosecutorial error? He, basically, in a more recent case, you said that it was error when the prosecutor said regarding another defendant. Now, she's had 2 years, a little over 2 years and 3 months to come up with a story about how she's going to explain that to the jury. And she had all weekend, this past weekend, to decide how she's going to respond to all of the evidence that she heard here in the courtroom that week. You said a prosecutor cannot do that. And there's really no difference in what this prosecutor did with Mr. Boatwright, and at least as far as insinuating that he was a liar. The prosecutor also may not vouch for the credibility of its own witness. And then this kind of interplays, this is where we go back to talking about Keyshawn Ivey. And the first issue, because that made more sense factually, to make it the first issue, he was an accomplice. He was given an immunity letter. And my colleague will point out to you that the word immunity isn't in that letter. But he's the guy that drove the car that was following the victim in this case, and the car from which the shots were fired that killed the victim. He is the only witness who places Mr. Boatwright at the intersection of 5th and Western when this incident took place 5 years ago this week. That's why I realize I'm kind of going back, I'm mixing up my issues now. But that's why this guy should be considered an accomplice. He wasn't just a co-defendant in another trial offering cumulative testimony. He is somebody who was promised that if he testified truthfully, and he changed his story a few times.
Why doesn't the general credibility instruction cover this? Isn't that what we're ultimately getting to? The jury has 2 different versions and they giving a general credibility instruction. And when it's not requested, didn't we decide that not in your favor in State v. Goins? How do you distinguish that?
Yeah, I realize that. And I guess, the big problem, this is one of those times when a client has requested an issue, and I thought it had at least had substantial merit in order to include it in the brief. There are very few cases where the accomplice that testifies has the sole evidence, the final key piece of evidence. And everything else in this case that points to Mr. Boatwright's alleged culpability, the texts that happen around the same time as the murder, the fact that the phone was wiped, that a gun with some of the shell casings from the intersection happened to be found in his house, but unlike one of the other cases, it's not like the evidence was in his pocket. This is the only person who says that Mr. Boatwright was at 5th and Western when this murder occurred. So that's why it's a little bit different than every other case that you have, I think. And I think in some ways too, it kind of also goes back to the second issue. It explains how important Mr. Ivy's testimony was to the prosecution's ability to get a conviction in this case, because the prosecutor thought it important in closing argument to actually vouch for the credibility of this accomplice. You know, he talks again, that a little bit, I used a little bit different words, but basically the same statement, you know, Trump commenting that, you know, when he was grabbed off the street and brought to the police station, you know, and interviewed for several hours. Look at the testimony and the statements of Mr. Keyshawn Ivy, because the argument has been made to you. How many times does a person have to be dishonest with you before you stop believing them? And a couple of other statements. And I want to make sure that I get to the other part. I don't want to leave here without talking about misstating the legal burden of proof. The prosecutor said, one of the statements that he said in closing argument was, when people conspire to commit a crime like murder, they don't necessarily agree ahead of time to make it fair for the police investigating these cases. Basically, he was telling the jury, if there are any holes in this case, you have to assume that it's in my favor. That's shifting the burden of proof, and that's also not allowed. And then I'm not able to get to the final point, which is for some reason, he talked about senseless violence, and I think that that's a stoking of fear in the neighborhood sentiment. I realize I'm over time, Your Honor. I'll come up for rebuttal.
Thank you. Ms. Litfin?
Good morning again. May it please the court. The state appears by Deputy District Attorney Jody Litfin. Your Honors, I will go ahead and start with issue 2 as well, since that's the main focus, I guess, of the brief. And there are numerous claimed issues of prosecutorial error. Our position is that none of these 5 different claims, I want to say between 11 and 12 and 13 different statements are prosecutorial error. So we don't even meet the first prong. They're not outside the wide latitude. But as the backup, we have the harmless error argument if this court does find that any of these statements are error. I think in preparing for this, well, let's put it in context, right? Because context is key, and the state did say that these comments are simply being pulled out of context, isolated, and argued as error, which is not what this court needs to do. We look at it in context. The prosecutor's closing here has had 3 parts. 1, the prosecutor talked about a detailed recitation of the evidence and what the state presented, as well as what the defendant testified to. 2, the law that applied in the case, and then the concept of reasonable doubt. The first 2 parts were really focused on in the initial closing argument, and the third part was in the rebuttal closing, which is the majority of the comments that the defendant is complaining about. And during defense counsel's closing argument, it really did pick apart the testimony of Keyshawn Ivy's, the testimony of Keyshawn Ivy, his statements, because really that's how the defendant gets placed in the car, was Keyshawn Ivy's testimony. The first kind of 3 issues, the Doyle violation, the claimed calling the defendant a liar, and the vouching for the credibility of Keyshawn Ivy, I think we can kind of take those together. And again, in context, if you look at rebuttal closing, the prosecutor is doing what is permissible, which is the defendant has provided testimony in this case. He's provided a theory of defense. Now you can, as the jury, look at what evidence has been presented to support that. Statements of counsel are not evidence, which he repeated over and over again. His statements weren't, defense counsel's statements are not. Let's look at the evidence to support his theory. He wasn't calling him a liar. It was an evidence-based argument of the defendant hasn't produced any evidence that Jeffrey Walters was the actual shooter. And you can take into consideration when the defendant testified that he wasn't there and was at the motel, he has a bias in this case. I mean, that would benefit him to say that, but what evidence is there to support that he was actually at the motel during the time of the shooting? Conversely, let's look at Keyshawn Ivey's testimony. What evidence is there to support his testimony? Again, evidence-based argument, not simply calling the defendant a liar. Certainly not like in Paps where they did it 11 times, or in Brown where they called the defendant's testimony a story or a tale, talking about that she had the opportunity to decide what her testimony was going to be. The prosecutor here was saying, look at the evidence, look at the testimony, who does it support? So our position is that this was not a Doyle violation, and notably, the defendant testified that he did not, he invoked his right when he spoke to the detectives here. So the jury knew why he didn't provide a statement. He told them, I invoked my right to remain silent. So that's something else that the jury could consider. And then the other comments about misstating the burden of proof. Again, the state does not believe that that is what happened here in context. I'm trying to remember the exact statements that he was saying when they were claiming that he was misstating the burden of proof. I think the prosecutor there was just talking about, you have to put together some pieces here. This wasn't Keyshawn Ivey's testimony was really important, but there were other pieces of circumstantial evidence, the phone records, what Danielle Morrison said about the job done text, about Mr. Alston saying when he was saying that Mr. Payne was leaving. So there were these little pieces that put together the conspiracy, and there were these little pieces that put together the planning of the murder. He wasn't saying that it was, if we have to fill in the gaps, it goes to the state. He was responding to defense counsel's argument that, well, we don't know what's on the phone. They didn't present to us what's on the phone. Well, that's because the phone was wiped, and we explained why those things might happen. And you have to kind of put together these pieces in order for the jury to figure out the conspiracy here. So we don't believe that he was misstating his burden of proof there. And then appealing to the community interest, we also don't believe that he was doing that when he was talking about senseless violence. The motive here, it wouldn't make sense for all people that the motive is, this guy kicked in my door, so I'm going to murder him. Or he's having a relationship with the woman that I'm having a relationship, so we're going to kill him. It was senseless violence. The motive doesn't ring true for a lot of people. And I don't think that was inappropriate for the prosecutor to note that. In context, we believe that the prosecutor's arguments were all proper. If this court's find that any of them are improper, we would argue that for harmlessness, number one, there was no objection, which the defense counsel does not have to object, of course, but it can be used for harmlessness. There were preliminary instructions here that the jury had about statements, arguments, remarks of counsel are intended to help you in understanding the evidence, but they are not evidence. If any statements are made that are not supported, they should be disregarded. Preliminary instruction also to the jury was to presume that the defendant was not guilty. It's the state's burden of proof. It's always on the state. And in closing, they were given those same two instructions. So we presume that the jury followed those instructions here. And then lastly, the strength of the evidence secondarily can support harmlessness here. And I can go through all that if this court wants, but it's listed in my brief as to the circumstantial evidence, as well as Keyshawn Ivey's testimony, putting the defendant there, and sort of the circumstances and timeline of the murder. And then I can go through issue one if the court has any questions about issue two. I can move on to issue one, which is the accomplice issue. Our position is that Keyshawn Ivey was not an accomplice witness here. When we're looking at this, there was no request for an accomplice witness instruction, so we're in the clearly erroneous standard, or this court must be firmly convinced that the jury would have reached a different verdict had this instruction been given. First of all, we're looking at whether it was legally and factually appropriate. It depends on whether Ivey was actually an accomplice, and our position is that he's not. An accomplice witness is a witness who testifies that he was involved in the commission of a crime with which the defendant was charged. And there are 3 points that the defendant argues support that Mr. Ivey was an accomplice witness. We disagree with all of these. First is the fact that he received this immunity letter from the DA's office. We disagree that this is an immunity letter. It's more like a letter of outlining the cooperation that Keyshawn Ivey had with the state. Importantly, it says that it appears that he was present at the scene of the shooting and drove the vehicle to attack. That was used by the assailants to attack Mr. Payne. Mere presence at the scene does not make one an accomplice. Mere presence,
This was more than mere presence. He was the driver of the vehicle, wasn't he?
He was the driver, Your Honor, but I would disagree that it's not
with Mr. Boatwright sitting right next to him in the passenger seat.
correct, Your Honor. But he did not, according to his testimony, he did not know that the shooting was going to happen. We also have the detective's testimony saying there's no other evidence that links him to the murder. He brought a gun with him, granted, and there was a lot of testimony, I think, in this trial about members of gangs, and I think that can be inferred that often they have guns with them. So I don't think that in and of itself shows that he knew that there was going to be a shooting. And the fact that Mr. Boatwright was the one to direct him on where to go. Mr. Boatwright was the one who received the phone call and asked him to go make a play, which he didn't say that make a play to him meant go commit a drive-by shooting or a murder. So I don't think it's, even though he was the driver, he didn't share the intent to commit the crimes. He wasn't involved in the commission of the crimes. And I would argue that it was just his mere presence being the driver. The second point the defendant argues is, I guess I've kind of hit on it, the fact that Mr. Ivy testified that he drove to the mansion armed with his gun to make a play and had previously seen the defendant with a gun. Again, this doesn't really establish that he was involved in the shooting. The defendant did direct him and ask him to go to the mansion to make a play. They all got in the car. At his direction, he drove to the mansion, and once there, the defendant said, okay, never mind, let's head back to Walter's house. As soon as he turned onto the intersection at 5th and Western, he heard the gunshots. He ducked down. He claims he had no idea that they were going to do this. Nothing was ever said before they drove through the intersection or after the shooting. And he said at the time he considered him a good friend, but in hindsight, that really wasn't true because he put him in a messed up situation. So his testimony was that he did not know this was going to happen. And simply driving there with a gun or seeing the defendant with a gun does not establish that he was an accomplice. He also didn't know about the beef between Alston or Payne, or that there was previous tension between the two. He didn't know about the situation where Mr. Payne had kicked in the door, and he had testified that he had no reason to kill Mr. Payne. And third would be what the state is considering just mere speculation that just because he was at the mansion with these same people about a month before the murder, he likely would have had to hear the planning of this murder that happened. This doesn't establish that he was an accomplice, and he testified to the contrary. He said while he was at the mansion about a month prior to the murder, he did not hear what Alston, Clayton, Williams, or Mr. Boatwright had to say. He didn't hear what they were talking about. He denied having any conversations or discussion about planning a murder. And even if this were true, this court's case law says the mere presence during the planning of a crime also does not make one an accomplice. So our position is that there was no factual basis for this instruction. It wasn't legally appropriate. It wasn't error, let alone clear error. There are 3 factors that we can go through. If this court finds that it's error, we would argue that all of these factors are present here. Whether the accomplice testimony was corroborated, it was. Whether the motivations for testifying were disclosed to the jury, which they were. The jury saw his entire 2-hour interview with law enforcement, how he kind of slowly started to talk about his involvement. And first he heard it was Mr. Boatwright, and then it was because I was there. So they were able to view that and consider it. This letter was presented to the jury as an exhibit. Also, the jury heard that he had been charged with a firearms case in a federal case and had a pending one. So they were aware of all of these things. He was cross-examined, and his credibility was attacked during closing argument. And then, as Your Honor was pointing out, this jury was cautioned about and given just the general weight and credit to be afforded to testimonial evidence, that instruction, preliminarily and at the close of evidence. So our position would be, even if this court finds error, it was not clear error considering those 3 factors. And then, of course, our position would be that there's no cumulative error here as well. So I don't believe I have any further presentation. We would just ask this court to affirm the convictions in this case.
Thank you.
Well, as my colleague said, Mr. Ivy knew. He said his testimony was, as far as I knew, I was going there to make a play. He had his own 9mm gun underneath my lap, and I don't know what that means. Was it sitting on his lap? Was it sitting under, between his thigh and the seat? Or was it somewhere on the seat? He had his own gun. I also, well, he maybe wasn't part of the kitchen debate between Alston, Boatwright, Clayton, and Williams. If you've seen the exhibits of the mansion and the kitchen area and the living room, there's like a tiny chair. There's, I mean, opening between the kitchen and the living room is huge. It's, there's barely a wall there. He was there the whole time for 2 hours. He didn't hear them talking. He knew. And then, of course, there's what happens the next day, according to Clayton's mother, which is, I suppose there was, I think a detective maybe testified differently, but Tequila Clayton testified the next day that it was Ivy who said to Clayton, "Man, that's crazy. We got that nigger." So, he knew what was going on. He was an accomplice. And the fact that the letter does not actually say immunity, you can't say it's not an immunity letter just because it doesn't have that word in it. That's not the way it works. Also, the comment about they don't necessarily agree ahead of time to make it fair for the police, that couldn't be in a response to anything that defense counsel had said in closing argument, because defense counsel hadn't gotten up yet. That was in the prosecution's open, and I never know what to call it. I call the first part closing and I call the second part rebuttal. So the prosecutor's closing argument was in that. Defense hadn't given its closing yet. It wasn't in rebuttal. The fair for the police comment was in that part. I'm not seeing any further questions. Thank you very much.
Thank you. Thank you to both counsel. The court will take this matter under advisement. I will now call case number 125754, State of Kansas versus Yeargin-Charles.
Good morning. May it please the court. I'm Ryan Enninger, appearing on behalf of the appellant in this case, Mrs. Shara Yeargin-Charles. With the court's permission, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you, Your Honor. Following the district court's denial of Mrs. Charles's motion to suppress, a Jackson County jury found her guilty of possession of methamphetamine, as well as an additional count of interference with a law enforcement officer. There were also a number of misdemeanor convictions that aren't really subject to this appeal at this time. The issue before the court rests on the district court's denial of Mrs. Charles' motion to suppress. The statute and the argument that we've made is that the officer in this case lacked reasonable suspicion to conduct the traffic stop that ultimately led to Mrs. Charles' arrest and conviction. The statute at issue is KSA 8-133, and that reads, "Every license plate shall be securely fastened to the vehicle to which it is assigned to prevent the plate from swinging, and at a height not less than 12 inches from the ground, measuring from the bottom of the plate. The license plate shall be fastened in a place and position to be clearly visible and shall be maintained free from foreign material in a condition that is clearly legible." What I've argued for the court in the brief and what before the Court of Appeals, what I argued before the Court of Appeals, but the brief in the Court of Appeals is that there is no reasonable suspicion here for the officer to conduct this traffic stop based on this statute. What we've argued is that this statute, first of all, should be construed and interpreted by the court for this no hanging or swinging provision to really be read all together as one statute and not as necessarily separate components. They all have some relation to each other, and the purpose of that is so that the plate is clearly legible. So an officer following from a safe distance is able to identify the vehicle. In this case, there was no question, no issue whatsoever that the officer was able to identify the vehicle and take the tag number. So that's sort of the first part of the argument. The second part is, even if the court disagrees with that, and that is a separate, and these are very, very separate, distinct requirements, and that part of the statute isn't really related to the other, then we will argue that in this case, there's no factual finding by the district court that this license plate was swinging in the terms of the statute. The district court, I focused the court's attention on the district court's memo in this case, where he said he only spoke about the officer's testimony at the preliminary hearing. At the preliminary hearing, officer only stated the vehicle or the license plate was only attached by one bolt and it was askew. He said nothing, the district court didn't make any factual finding that it was in fact swinging. And later at the suppression motion, there becomes this issue of, well, the officer now says it was flapping. So now if it's flapping, I've also argued that in the brief, if it's flapping, that's different than swinging. And I think there's also some issue with the Court of Appeals and the district court's reliance on the only way this has sort of been addressed before is through the federal court. The 10th Circuit has two opinions, Velasquez and Lopez Estrada. And the district court relied on those two opinions in its memo, finding that denying her motion to suppress. And what I've argued is that this court really shouldn't adopt those findings to interpret and apply this statute in this case under Kansas law. And I think there's some significant distinguishing factors from those two cases that I would like to direct the court to just quickly. In Lopez Estrada, there were actually, in both cases, there are two bases for the stop. So it wasn't just the license plate. There was also some other reason that was also upheld by those courts justifying the stop. Also in Lopez and Estrada, there was the officer observed that the license plate, I believe in this case, he was following the vehicle, observed that it was, the license plate was held on by a wire. And he testified that although it wasn't actually swinging when I saw it, I have seen plates attached in a similar fashion that as soon as there's some sort of wind, it will start swinging everywhere and make it illegible. Also, in Velasquez, the officer was traveling in the opposite direction. So he sees the vehicle at 70 miles an hour. And he sees the vehicle traveling the opposite direction and sees that the front plate is askew. And that court in that situation held that even though the officer was just unable to determine at that point, I see that condition and I think, well, maybe that might cause it to be unsecured. It might cause it to swing. So at that point, he had a reasonable suspicion to investigate. And so I think those two cases are distinguishable from the facts in this instant case. I don't think that the court should just hang its hat on those two opinions. And I also, in reviewing for this, I noticed that in the district court's memorandum of opinion, I was focused on these two 10th Circuit cases. But at the bottom, the district court does have a but C and cites a case from Vermont in his memorandum opinion, which is kind of, I don't know if the court didn't want to go all the way, district court didn't want to go all the way through an analysis and just kind of went, well, here's a but C. But that case is a Vermont case. And in that case, I think it's State v. Tuma. It discusses exactly what I'm asking the court to do. And it looks at the Vermont statute and says, well, these requirements of how it's affixed and the question exactly.
Driving down the road.
Right.
Was there, you've argued there's no evidence of swinging. Was there any evidence of an insecurity?
That's the other point, Your Honor. And that's exactly, I mean, obviously there is some security question here of safety, a traffic safety matter. That didn't happen here, but yeah, I don't think there's anything, there's nothing here in the record to show that it was unsafe. There is a photograph of the license plate itself in volume 1, I think page 85 or 90 or something. But anyway, it just shows it being askewed and it's fastened by one bolt. I mean, we're all familiar with that sort of, it's not a tiny little bolt, it's a decent sized bolt that goes into that license plate. That license plate is a rather heavy gauge.
Your argument is
it's not
that
unsafe.
If the bolt is securely cinched down, then
right.
the plate is secure.
It's secured, right. And to the extent that it's, and the facts were here that it's not moving everywhere. It's not swinging in a manner, like the statute says swinging. Well, you think about, well, like in this case where it's tied to the vehicle with a wire. Or, I mean, clearly the legislature doesn't want you to flip it over, right? Just married on it and trail it behind your vehicle somewhere. So I think to the extent that there's a safety concern, that's not present here at all.
Did the detective or deputy Dobler or Dobler?
Dobler, I
Okay,
believe, yeah.
did, he testified that it was moving while the vehicle was traveling, and he said like flapping in the wind,
Yeah,
so to
like
speak?
it was moving back and forth from the vehicle to the back of the vehicle, from the vehicle to the back of the vehicle. What's interesting is, like I said before and argued before, the district court never doesn't go down that road in its finding. It relies on what the officer's initial testimony was before the court at the preliminary hearing, when all he said was it was fastened by one bolt and it was askew, and I found that to be a violation, which is not a correct interpretation of the statute. There's no, and like in the Vermont statute for issue, the requirement is that it's horizontal. And there's nothing like that in our statute. It could be vertical, it could be horizontal, it can be as long as it's securely fastened. And in this case, the best evidence of that is the officer following behind the vehicle and it's barely moving. So I would argue then that it's securely fastened. It's not going anywhere.
So we would presume that finding was made, that it was swinging, and then you're asking us whether or not there's substantial competent evidence to support that implicit finding?
Right. I don't think there's substantial evidence because the district court never made that factual finding. And the district court didn't say, I looked and there was a dash cam video. And the district court didn't say, I looked at the dash cam video, even though it was urged to by the state at the suppression motion. I looked at this dash cam video and I'll just make a clear factual finding that this thing's swinging, and that violates the statute. But the district court hung its hat on, well, the officer testified during the prelim that it was askew, it didn't have both bolts. And there is some discussion about that during the suppression motion. They go down this sort of road of, well, my bumper looks like this and I should have 2 bolts and 1 bolt. So that seems like the state even at that point was somewhat confused about what the actual law was. Now there's no driving at this. Okay, we're gonna put on proof of swinging. That never happened. So does that answer your question, Your Honor?
I think so. Thanks.
Unless the court has additional questions for me. Thank you.
May it please the court, Chris Elsleger, Deputy Solicitor General, appearing on behalf of the state. And I'm here to tell you that the Court of Appeals got it right. The plain language of the statute says that the license plate must be securely fastened. And we had the testimony of the officer from the suppression hearing said the vehicle's registration plate was loosely secured by a bolt or a screw on the left side in the manufacturer's hole and was tilted downwards to the right, slanted downwards to the right, not secured by anything, and moving. He said the plate was obviously moving while it was traveling. And later he said it was flapping in the wind. I think that meets the plain language of the statute.
We all live here on the windy plains, and we're probably familiar with being out in strong winds. If I drive past an intersection, a stop sign intersection, and say, boy, that stop sign was really flapping in the wind, does that mean the sign is not secure?
Well, I don't know. I don't know that there's a statute that.
Well, there isn't, but it seems that
the sign is sticking up on a pole in the wind. A license plate is attached to a car, supposed to be securely fastened to the car, to the back end.
Well, that's what we're here to try to decide, whether there's any evidence of it being insecurely fastened and or swinging. And I went through the whole transcript. There's swinging doesn't show up once.
Yeah, but the officer said it was flapping in the wind, and I know there's been arguments that that's not the same as swinging, but if.
Well, why can't a license plate, maybe not in this case, but just hypothetically, you I think would agree that you could have a license plate that is very securely fastened which could still flap in the wind.
I mean, I can't say it's not in the realm of possibilities. I'm having a hard time considering that because up against the car, if it's securely fastened, it shouldn't be flapping. It's not like a stop sign that is standing up on a pole exposed to the wind. Up against the car, it really shouldn't. If it's securely fastened.
Whether or not it should be flapping is irrelevant. The question is that evidence that it's not securely fastened?
And I would say it is, because otherwise, I think you're asking for the officers to use like talismanic language to say that it was swinging as opposed to flapping in the wind or any other.
No, I'm
variation
trying
of the
to
English
discern
language.
what the statute actually prohibits. And I don't read in the statutory language a prohibition on a 1-bolt license plate. And that's essentially what this case comes down to.
Well, it comes down to really what does securely fastened mean?
Right.
And the state
And so
submits.
why can't someone securely fasten their plate to their car in an askew position with 1 bolt?
Because I think the askew position and the flapping in the wind indicates that it is not securely fastened.
Does that pass the common sense test?
I think it does. I mean, I could say, I mean, is it possible to get if you took 1 bolt right in the middle of the license plate, maybe that would be securely fastened. But if it's hanging and it's moving and flapping in the wind, at least that gives the reasonable suspicion that it's not securely fastened. Because that's what we're really here about, is does they also have reasonable suspicion? Taking your analogy or your hypothetical to the end there, I mean, I suppose it could be possible that the officer could get up there and say, oh, well, gosh, this license plate really is securely fastened. I mean, doubtful, but he doesn't have to know for certain. He just has to have a reasonable suspicion. And if he sees a license plate hanging askew and flapping in the wind, I think it's reasonable for him to.
Can't we read into the language the legislature chose, because they chose the word swinging? Can't we read into that reasonably that what they were concerned about was rotation around the screw?
Well, I don't know. I
flapping
think we're
doesn't-
parsing the word swinging too much. To me, I think flapping in the wind indicates something
So you
similar.
just want to be like close enough, swinging, flapping, whatever.
Well, again, I think if you're trying to get the officers to use talismanic language to say, oh, I saw it swinging, when he says,
It's not talismanic, it's just ordinary speech. Again, I'll go back to my stop sign. I think that's very common to talk about a sign flapping in the wind. It's very
Moving.
uncommon to talk about a sign swinging in the wind.
Well, but swinging is a kind of movement. I mean, how many different words could we use to describe swinging? I mean, you're asking the officers.
Is that really true? I mean, doesn't swinging mean that an object is rotating around a fulcrum? I mean, isn't that what that word means?
Moving.
No, it doesn't mean just moving.
Well, I think in common parlance, if the officer sees a license plate hanging and flapping in the wind, to him, that's swing, whether it's swinging this way or this way, it's swinging, it's moving. And
But
it's not, and the ultimate thing here is it says securely fastened.
Right. In your, just to sum up this line of inquiry, you're staking your case on the testimony about hanging askew and flapping. You're not arguing that there was something more than that.
I don't believe there was. Now, I'll have to admit that I came into this, I'm pinch hitting. The original attorney on this case has moved on to other employment, so this fell into my lap. Not 100% up to, I don't have the record 100% in my head. I'm relying on that and what's in the briefs and what the Court of Appeals said was relying on that. And I think I would point you to the federal cases that have already looked at this very statute here in Kansas and essentially agreed with the state. I realize they're not binding. The 10th Circuit is only persuasive, but the Lopez Estrada case, there's even, if you look at the Westlaw, I looked up on Westlaw, there's even a picture there of the license plate and it's just sort of hanging a little bit, similar to what was described here. And they said that was sufficient to provide a law enforcement officer with reasonable suspicion. And I thought what was kind of getting back to what I was trying to say earlier is that the 10th Circuit said that the Fourth Amendment doesn't require a law enforcement officer to actually see the plate swinging to stop the vehicle. He only needs a reasonable basis for thinking that an infraction has taken place, and a hanging license plate is sufficient. So again, whether it actually securely fastened or not, is it reasonable for the officer to believe that it's not securely fastened? And I would submit that seeing a license plate attached by just a single bolt hanging and flapping in the wind is enough to lead a reasonable police officer to think, hey, we've got a violation of the law here. The license plate is not securely fastened. And so obviously that's a reasonable basis to make this stop. And therefore the district court was correct in not suppressing the evidence, and the Court of Appeals, like I said, got it right. If there are no other questions, I would simply ask you to affirm the Court of Appeals. Thank you very much.
Thank you.
I think unless the court has any specific questions, I'd be willing to yield the remainder of my time on rebuttal.
Well, what about counsel's highlighting the testimony that the deputy said that the registration plate was not just secured by a bolt, but it was loosely secured?
I think
I mean-
that's his opinion. There's no evidence in the record whatsoever that.
What's his
You know, it's like if
testimony,
we had a
right?
demonstrative exhibit and we could test how far I can put the screw in and can I yank the plate off, then it would be unsecured. But there's nothing in the record to support that testimony from him. And I noticed that his testimony, as we go from the preliminary hearing, which it seems like his understanding, that officer's understanding of the statute was that it was violated by the plate being askew and only one bolt, to now we're starting to get closer to, he never actually testifies that it's swinging, but now he's getting closer and closer. He's saying the right words now, that he's in the form of getting inside the statute of saying that, well, it's loosely attached. Furthermore, I'd also say that the state says, and even to the degree of moving, the state points out to the district court that you need a keen eye to see it. And it's nighttime, 3 o'clock in the morning. But if you look really close, you can see it moving. And I think that might be, and clearly the district court wasn't persuaded by it. So, because it hung its hat on, as I said, on the officer's testimony at the preliminary hearing. So I think to the extent that there's some indication there now that the officer is saying that it was loosely attached by the screw, there's just nothing to support that beyond his just statement. Unless there's further questions, I appreciate the court's time this morning, and we just ask for a reversal. Thank you, Your Honors.
Thank you. Thank you to both counsel for your arguments. The court will take this case under advisement. We will now be in recess until 10:30 tomorrow. All right.